Mr. Rogers, is that correct?
Yes, sir.
Have you received a copy of the complaint?
Yes, sir.
We're on the record in case number 24 CRI 223, cases captioned State of Ohio versus Sir Christion Rogers. We're scheduled today for bonds and a complaint filed the court on July 26, 2024. We'll conduct this hearing by video. State of Ohio is represented by prosecuting attorney Christopher Tennell. The defendant is also present. Count one states in that on or about July 24, 2024, Ashland County, Ohio, Sir Christion Rogers did act with the kind of culpability required for the commission of offense and did aid or abet another committing the offense of robbery, ORC 2911.02A2. The underlying offense was a felony of the second degree, to wit, aid and abetted Harry Stevens and or James Phipps and or Robert Prater and or Traquan Thompson to commit robbery at Rite Aid, 419 Claremont Avenue, Ashland, Ohio. So on that basis, you do qualify for court-appointed counsel. I'm going to appoint attorney Zach Miranda to represent you in this case. We'll notify him of the appointment. He'll be present for next hearing. We are going to set up bond today. Mr. Tennell, again, what's the state's position on bond?
Thank you, Your Honor. The court should be aware that the circumstances of this offense involve this defendant and 4 co-defendants traveling from presumably the Montgomery County, Dayton area to the Rite Aid in the city of Ashland. 3 of those co-defendants entered the pharmacy wearing masks. They went to the back, entered into the secured area of the pharmacy, pushed an employee down and demanded that the safe be opened. The pharmacist then opened the safe pursuant to that demand, where they cleaned it out, taking all of the pills and other items in there. They then fled the scene. This defendant and another co-defendant were waiting in the car. This defendant then drove off with the 4 co-defendants. A pursuit with law enforcement from multiple counties, multiple agencies then ensued and ended in the Columbus area when the getaway vehicle ran out of gas. The defendant and his co-defendants will be looking at many serious felony charges when it comes to grand jury review besides what's in the complaint. The court should be advised that this defendant's OLEG only shows arrests. So the state is not aware of what the disposition may or may not be. It shows the Dayton Police Department made an arrest in 2018 for breaking and entering. Huber Heights PD in 2018 in a separate incident of receiving stolen property, 4th degree felony. The Sharonville Police Department in the Cincinnati area in 2019 made arrests for 5 counts of felony theft and a count of breaking and entering. And Dayton PD made an arrest in July of last year for the offense of burglary. And Trotwood PD made an arrest for the offense of theft in February of this year. There's also a warrant number showing out of Madison County, but there is no date, nor is there an offense attached to that warrant. Your Honor, based on the nature and circumstances of the offense, the state would request the usual conditions of bond, as well as no contact with the Rite Aid store or any Rite Aid. To that end, the court should be advised that this defendant and co-defendants are believed to be part of a larger conspiracy of persons that are robbing Rite Aids in Ohio and Pennsylvania. Pennsylvania authorities are on scene here in Ashland, gathering evidence in their case, in addition to what other Ohio agencies are gathering. So the state would ask no contact between the co-defendants and request a bond of $500,000 cash surety for real estate. Thank you.
Thank you, sir. Mr. Rogers, as far as today, the court is only setting bond. Court's not addressing the merits of the charge. Can you do have the right to remain silent? Further, sir, bond is something the court can always reconsider. So if you want to speak with Attorney Miranda before addressing bond, that's fine. I can set a bond today and we can always reconsider that. Is there anything you want to tell me today, though, before I post bond? Again, you do not have to.
Is there anything I want to tell you?
Yes, sir. Just as far as bond.
Just as far as bond?
Yes.
No, sir.
Okay. So the court's going to set bond as follows. To be released with the case is pending, they'll have to post 2 bonds. First bond is a personal reconnaissance bond. That's your written promise to the court to appear for all future hearings. If you would fail to appear for a hearing, be prosecuted with a separate felony offense called failure to appear. That's a felony of the 4th degree. In addition to this case, court's also requiring posted bond amount of $250,000. That can be posted with a surety bond, cash bond, or real estate posting. If you post bond, you're subject to the following conditions. 1, you're not to leave the state of Ohio while the case is pending. 2nd, you must appear for all future hearings in this case. 3rd, you must keep the court advised of your address and phone number at all times. 4th, you must obey all laws and orders of the court. 5th, you're not to use, consume, or possess any alcohol or drugs of abuse. You also be subject to RAM, drug, and alcohol testing at your own expense. Further, sir, if you post bond, you must enroll in the court's drug and alcohol testing program. Further, sir, if you post bond, you will be subject to GPS monitoring. What that means, sir, if you post bond or bill subject to GPS monitor, you have to weigh that while this case is pending. While you're in GPS monitoring, you have a curfew. You must be at your approved residence 24 hours a day, 7 days a week. You may only leave your approved residence for work, previously scheduled meetings with your attorney, court proceedings in this case, and for emergency medical appointments. Further, sir, if you post bond, you have no contact whatsoever with the alleged co-defendants, Carrie Stevens, James Phipps, Robert Prater, and Taquan Thompson. And finally, sir, if you post bond, you're not to be on the premises of or within 500 feet of any Rite Aid store. Sir, do you understand the conditions of bond?
Yes, sir. Did you hear me?
Yes, sir. Thank you, sir. Mr. Town, would you be available on July 29th at 10 o'clock for an initial appearance hearing?
Yes.
Okay. All right. Mr. Rogers, we're going to schedule your next court hearing for this coming Monday, July 29, 2024 at 10 a.m. We're going to do that by video. If you do post bond before then, just come to our courthouse with the Ashland County Court of Common Pleas. We're in downtown Ashland on 2nd Street. Just come to the top floor again Monday at 10 a.m. We'll make sure you have computer access. Do you understand that, sir?
Yes, sir.
Mr. Tell, anything further today?
No, sir. Thank you.
Thank you all. We're adjourned.